Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, Bobby, it is so great to be back with you today. Last time we were here, we started talking about what to expect when you go to court for the first time. Potentially you have a hearing for a temporary custody for your children. And, this can be obviously a really big deal, especially if you've never been to court before. So last time we talked a little bit about what to expect before, but today we're going to talk about when you're actually in that hearing, what you can expect and kind of the way that you should act, that type of thing. So, Bobby, it is so great to be here with you today. How are you doing?
I'm doing great. I'm excited to be back on another episode, of course, and to be talking about something that can be really nerve-wracking and can be really scary because, let's be honest, most of us, thankfully, don't go to court very often, if at all. So stepping into a courtroom can be pretty scary if we don't know what is what. So the idea behind this episode, the last episode, is to break it down a bit so people can really understand and not be so scared. And
Yeah, absolutely. I mean, because Bobby, when you think about it, most people aren't, thinking about ever going to court, and you kind of think through it of, okay, well, that's for criminals. That's for
Mhm.
people that have broken the law, right? And so I think that you can be a little defensive because you're like, well, hold on, I haven't done anything wrong. I'm just trying to, get divorced from my spouse, but I do think it kind of brings some of that anxiety and nervousness into that environment because I think mentally sometimes you just think that okay, well, the court is for criminals, right? But we're not here for that today. We're here to really talk about, divorce. So, what are some of those things? Maybe why don't we start with maybe your mindset and what your mindset should be going in that day when you're stepping into that courtroom?
I think the first thing is that, like you just said, we associate courts with criminal activity. And I think that naturally flows into people feeling like when a judge makes a ruling, they're like judging you, like literally judging you and saying you're a good parent or you're a bad parent. And so that just ups the stakes tremendously. And so we need to get rid of that notion. The judge doesn't honestly care if you're a good or a bad person. They're just about the evidence and what's in the best interest of the child. And let's be honest, a judge who knows you just from seeing you in court can't possibly make those sorts of determinations. So we really need to lower the stakes and understand that if a judge makes a comment in court about you or says, makes some one-off, opinion, it doesn't mean that they think you're the bad parent or they're biased against you or anything like that. It's just the judge doing their job, and it's not personal. So let's just back away, from that notion.
Absolutely, that's such a great point. And today we're talking about, potentially it's a temporary custody hearing. So, you always talk a lot about how the judge is really thinking about the kids, right? The judge is not just trying to decide who's bad, who's winning, who's losing, but they really are trying to decide what's the best for the children, correct?
Yeah, the judge is not going in here, and there's not going to be a moment where the judge stands up from the bench and says, "Congratulations, Dad, you are the better parent. Mom, you should be ashamed of yourself," or vice versa. Like, people want that to happen because I think they have a lot of anger or resentment. And to be honest, where we are, what we're talking about here is we are having a hearing on temporary parenting time, which means that we've already tried to negotiate this and we've failed. We
Mhm.
haven't gotten to a schedule that works. We've maybe even gone to mediation. We probably have, and that hasn't worked either. So now we're going into the courtroom, and emotions are not as cool as they were when they started. We're feeling anxious that there isn't a schedule yet. So it's understandable that people think it's going to happen that way, but really the judge is just focused on the kids.
Yeah. Do you think judges ever get frustrated that parents were not able to work that out on their own?
I mean, to be honest, yes. I think in we all want parents to be able to work it out. on their own, and judges will continue. Like, when you go into court, what people think is going to happen is that it's like, well, I don't want to talk to you out of court. We don't need to negotiate anymore because we'll just let the judge decide. And that is the last thing the judge wants to hear, because at the end of the day, the judge can't be there for every decision that you and your co-parent need to make for the next, 15, 18 years or whatever it is. The judge almost wants to do everything possible to avoid making a decision, to force the parties to continue to have to negotiate. So I think there's a natural frustration with judges, and that's just the right temperament or the right attitude for a just judge to have.
Yeah, yeah, and I mean, there's no better, way nobody knows your schedule better than you do, and, the 2 of you are gonna have to work out, how you're getting your kids to school and where they're staying the night and all of that and getting them to their activities, and, just no one cares more about that schedule than yourself, just
Yeah,
truthfully, and
absolutely. And the judge doesn't know the nuances of, maybe your boss is more flexible than your
Mhm.
co-parent's boss, or maybe, your mom can step up and get the kids sometimes. And if, like, we all actually work together, it just works so much better, kind of getting the whole village working to raise this child, rather than a judge just saying, okay, you have, week 1 and you have week 2, figure the rest out.
Right, right. That can be really, really frustrating, actually. So why don't we talk about, let's say, we come to the hearing, we are here, we're in court. What does that flow and that communication look like for the hearing?
So what's and then this is different in every courthouse, and it's slightly different. So what I explain here might not be exactly how it works. You want to defer to your lawyer; they'll tell you. So that's kind of the first thing that should happen, is that you're going to meet your lawyer at the courthouse, and if they haven't already kind of had a phone call with you or a conference prior to this date, they're going to tell you, okay, here's the nuts and bolts of what to expect today. They might say, I want you to wait outside the courtroom. I'm going to go in and have an initial conversation with the judge. Or they might say, come into the courtroom while we get the case called. Either way, the case is going to be called, meaning the judge's clerk is going to say, okay, Smith v. Smith, please step up to the bench. And your lawyer, the other side's lawyer, and possibly you and the other side are going to step up to the judge, and the judge is going to say something like, what are we up for today? Meaning, why are we here? What's the status of this case? The judge relies on the attorneys to give the judge an overview of kind of what happened last time, what's pending, what you are, quote unquote, set for. And so you, or excuse me, your attorney or the other attorney will say to the judge, well, judge, we're set for a hearing on a temporary parenting time schedule. At that point, the judge might ask some questions. Well, did you guys go to mediation already? Yes, judge, we went to mediation, but it wasn't successful. Have you guys attempted to settle this case? Yes, we have. And at that point, the attorneys are going to start to position themselves. And this is the art of lawyering. Your lawyer might say, judge, we've gotten really close, but the other side is unwilling to give up Wednesday nights. And then the other attorney will say, well, judge, that's not quite true. There's a problem with Wednesday nights, and they're going to dive into it and do their little lawyer thing. And the judge will say, well, before we go to hearing, I want you guys to go out in the hallway and see if you can figure it out. And so that's the first time where the judge is really going to be exemplifying that idea of, I don't want to figure it out. You as the parties need to figure it out. And so you'll go out into the hallway and start to have a conversation.
Yeah, it's like there's one more Hail Mary, to give you, which really is a lovely thing because it's, again, giving you the opportunity to advocate for yourself, to maybe potentially come up with a plan that works, better for the 2 of you than what the judge might come up with. So I love that you get potentially one more shot to work it out on your own.
And to be honest, it might not even be the last shot to work it out on your own, because what will happen is, you'll go out in the hall, you'll have your conversation, see if you can get some movement on the negotiation. And oftentimes what the attorneys will come to as far as a conclusion, they'll say, you know what, maybe if we just get the judge's opinion or recommendation, we can avoid this whole hearing. And what that looks like is the attorneys will go back into the courtroom and say to the judge, we're really close here. We think we can avoid this hearing if we could just have 10 minutes of your time in the back. And what that means is we're going to go into chambers. We're going to do something called a pre-trial conference or a pre-hearing conference. And that's going to be an informal conversation with the judge to dive into the facts, and make some arguments to the judge. And then the judge makes some suggestions for settlement. So we try to do that quite often because the hearing itself is not something that any of us want to do. I mean, certainly there's attorneys that love to fight, love to litigate, and they will be happy to go to a hearing. And a hearing might be important to get some leverage if the other side is completely unreasonable. But most of the time, if we can avoid the hearing, it's just better for everybody. The hearing is long. The hearing is aggravating. We're going to dive into personal information. You're going to be swearing to tell the truth, and you're going to have to answer these questions that you might not be comfortable with that answering. It's not a fun process. So if we can avoid that in a more constructive way, we're going to try to do that.
Yeah. And, made me think about when you go back to the chambers, are you sort of giving your elevator pitch or like showing a little bit of evidence from your side? And then based off of what the judge says, is that kind of even though it's not the ruling, you are getting an idea of what their thoughts are, right?
Exactly. And, you're going back, and let's say that I represent the mom and I'm making an argument to the judge. And in this case, the mom is living closer to the school and she's been the primary caretaker, and the dad traditionally has been working a longer job. I'm going to say to the judge, listen, throughout this party's entire marriage, this is how they have functioned as co-parents. And for the sake of the stability of the child, it makes more sense that mom would get the vast majority of the time initially, at least to start, to maintain stability for the child. And the dad's lawyer might retort and say, well, my client, he now has an opportunity to have the child more. He's thinking about moving closer to the school. He has more flexibility in his job. He's able to accommodate a 50-50 schedule. And that's ultimately what's better for the child, because the child should be having close contact with both parents. So they're going to really push forward their side, their arguments, and the judge, because every judge is different and their opinion on how these things should work and what is in the best interest of the child can be different, because that's a pretty subjective standard. You'll get very quickly an idea of where the judge is coming from, and then you can use the judge's opinion as leverage. So once the judge gives their opinion and says, well, I'm really inclined to the stability of the child is really important. Sounds like mom, has been providing that. Unless I hear something compelling at the hearing to change my mind, I think mom's suggestion for the schedule makes the most sense. Go back out in the hall and see if you can figure it out again. And then at that point, you're negotiating again, but you have the judge's opinion, and you're, hopefully that gets you to where you need to be.
Yeah. What makes me think too, you're talking about in the chambers and the judge is sort of talking to the attorney. You could also be in the courtroom and the attorney is talking to the judge. Are there times when the judge is actually speaking directly to one of the potential ex-spouses, and how do you correctly address the judge? Because I can imagine that might be a little nerve-wracking.
Yeah, absolutely. Well, and what sometimes will happen is in one of these pretrial conferences, the judge will be very adamant about a certain opinion. And we know as attorneys that our client kind of needs to hear it from the horse's mouth, if that's the right expression. They need to hear it directly from the person who it matters the most. whose opinion matters the most. Like if we go into the hall and say, listen, to the judge is really not a fan of disturbing this child's schedule at this point, I don't think going to hearing is going to make sense. And, the dad or the mom, whoever it may be in this case, is going to say, well, that doesn't make any sense to me. I really think we should go to hearing. We might say to the judge, listen, this is going to be, we're going to go to hearing. My client's going to demand that we go to hearing unless we can get this resolved. Can we have part of this pretrial conference in the open courtroom? Basically go out there and have a conversation with all of the parties. And at that point, the judge might ask you or the other parent some direct questions, and that can be very intimidating. They're sitting above you, they're wearing a robe, they're very direct in how they ask the questions. So what you need to do if you're asked the question by a judge is just, see what you can do to lower your heart rate and just listen to the question, exactly what they're asking. They're not trick questions, and just answer it as plainly and succinctly as possible. Don't, over answer. Don't dive into all the details. My mom would be horrible at this, by the way.
We all have a friend or a family member that
Yeah.
would be horrible. The over-explainer,
Yeah, exactly. The one who you ask her a question, she digresses. You ask her what she bought at the grocery store, and she's telling you about the clerk's son's college education before you know it. So don't be my mom in this circumstance.
Yeah, don't be Bobby's mom, but we love Bobby's mom. But and it makes me think, you've talked about, like being succinct and not getting emotional. Why are some of those things so important to remember? Because there's a why behind that.
Yeah, absolutely. Because the judge is looking at, the judge has limited information always, and they're looking at how you answer. They're looking at your temperament. They're looking at whether or not you're pointing the finger at the other side, because ultimately they need to figure out what's in the best interest of the child. And if you are getting visibly upset just over some very basic questions, they're going to go, well, wait a minute. Is there some sort of, anger issue that one side has? Or I can't imagine that this parent's very good at co-parenting if they can't just answer basic questions, or if they're taking everything personally. So you need to present yourself as diplomatically as possible. As you're the reasonable peacemaker, basically, is the best position to take in a scenario like this.
Yeah. Okay. So a lot of deep breaths, and we're going to be succinct. We're going to be respectful. We're not going to be emotional. These are all really, really good. And just always, of course, focused on the kids. And so, Bobby, let's say we go through all of this and the judge comes up with something and your client doesn't like it. They don't like the temporary custody order. What happens, or what can be done?
Sure. So let's say we go through the entire hearing, and what the hearing, let's say that, first of all, we can't negotiate a resolution. We just can't get there. Either you don't agree, or the co-parent, the other side, doesn't agree with this possible negotiated settlement. They're just like, no, I want the hearing. Well, what's going to happen next is you're going to be sworn in, and then each side is going to have an opportunity to ask questions of you and the other side. And that whole process might take, a half an hour, 45 minutes, 3 hours, depending on kind of how involved it gets. And then the judge may or may not make a decision on that same day. The judge might say, I need a week to think about it, come back in a week, or they might make a decision right there. Once they make that decision, that's going to be memorialized. That's going to be written down on a piece of paper called a court order. The judge is going to sign it, and then that is law for you until further order of court, as they say. Basically, until the judge changes it, or until the parties agree to change it. Because you can always agree with the other side to change the parenting time order. Judges rarely throw a wrench in the works if both sides say, you know what, this schedule doesn't work for us. We've tried it. This other thing is going to work better, and we both agree to it. The judge is going to say, great, you did what you're supposed to do. You're supposed to agree and figure things out. So I'll sign off on it. But if you don't agree with this order, well, you have to follow it for now. You being difficult, not following the order, causing issues is only going to make things worse. The best thing you can do, let's say that you're the parent that didn't get as much time as you want, you should be bending over backwards to be the flexible parent. So usually the other parent, things come up, they want to go out, or their job called them in and they need someone to pick up the slack. The more you can pick up the slack, the better. Then you can go back into court and say, hey, you made this schedule, but here's all the times where I actually had to pick up the slack, and we actually effectively have 50-50 now. Can we put that in writing? And that's a pretty compelling argument to make to a judge.
Yeah. Okay. All right. So at this point, whatever it is what it is until further notice. It is temporary, but it's there. Okay. Well, I feel like we've been through a lot today. Next time we can talk about, after the ruling and what to expect, how to, navigate the new schedule. And I guess if you're unhappy, trying to come up with ways to maybe change it. Anything else you want to kind of mention before we close out today, Bobby?
I mean, I think just to double down on what we said before, which is it's always better to negotiate than force the hearing. There is that 1% time where your lawyer is going to say, you know what, they're being so unreasonable. I can almost guarantee that the judge is going to give us a better result if we go to the hearing. I mean, that's usually pretty clear when that's going to happen. The judge will make a suggestion, and then the other side says, no, forget your suggestion. I want to do what I want to do. In that case, it's like, well, let's go to hearing, because the judge already said that they're open to something more in my favor. But in the vast majority of cases, let's see if we can negotiate, because that practice of negotiating with our co-parent is something we need for the next 18 years, possibly.
That's right. All right. Well, Bobby, thanks so much for being here with me today. Always great to be with you. And I love your perspective on divorce. Always focused on the kids, always focused on, making it as clean as possible. And, everybody loves that about you. If anybody has any questions about today's podcast, or if you have any future topics you'd love for us to discuss, please just mention them in the comments, and we will most likely talk about it in a future episode. Until then, we will see you next week.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.